welcome you to the fourth in our presentations during the symposium. We, I think, are very fortunate tonight. I know I'm truly excited and looking forward to this night's presentation. I will introduce our respondent after the speaker has finished. But I'm truly delighted to have Oliver W. Hill, one of the senior partners in the law firm of Hill, Tucker, and Marsh, as our speaker this evening. There are probably few persons more qualified to speak on civil rights and the Constitution than Mr. Hill, who has spent a career of over a half-century dealing with just those issues. A graduate of the Liberal Arts Division of Howard University and also of its School of Law, Mr. Hill became a member of the Virginia Bar in 1934 and has practiced law in Richmond since 1939, with the exception of time spent in the armed forces during World War II and his service with the Federal Housing Administration under the Kennedy and early Johnson administrations. He has participated in truly a myriad of civil rights cases. Among them were suits to end discriminatory salary scales for the younger Buck Skinners in the audience. That goes back to the 30s and 40s, where black teachers with the same experience and educational qualifications were, by state law, paid less than white teachers. Also, suits to obtain the right of Negroes to serve on juries, to provide free school bus transportation for black as well as white children, to obtain the rights of black citizens to vote in primary elections, to eliminate the segregation of blacks on common carriers, such as trains and buses, to establish the right of Negroes to use schools, parks, libraries, and other public facilities equally with whites, to protect blacks in their constitutional right to use the courts to seek redress of grievances without suffering harassment for so doing, and to receive their rights to be able to purchase the housing of their choice. And may I remind us that while I say to protect blacks in these rights, it really is to protect all of us in these rights, because who knows at what time any one of us or our progeny may be in a particular minority. He has served on numerous boards and is advisor to or member of a number of nonprofit, civic, or government organizations, including the NAACP, the Richmond Urban League, and the State Commission on Constitutional Revision. Mr. Hill was the first black to serve on the Richmond City Council, and he has served on the President's Committee on Equal Employment Opportunity. He is the recipient of numerous awards, and most recently in June, retired Associate Justice of the Supreme Court, Louis F. Powell, presented Mr. Hill with an award from the Virginia Commission on Women and Minorities in the Legal System at the annual meeting of the Virginia State Bar. Tonight, Mr. Hill has informed us that he will not only speak to the civil rights cases listed in the symposium casebook, which some of you, hopefully, have read, but he will also discuss the differences in constitutional interpretation between Justice Bradley, who wrote the majority opinion in the civil rights cases of 1883, and Justice Harlan, who dissented on that occasion. It is my pleasure to present to you at this time Oliver W. Hill.
Thank you very much, Professor Westin. I hope that the speech will be as excellent as the introduction. I don't know what building was. We just come across the lake over there, and we were having a very excellent meal. And Mr. Jones, who seated at the same table I was, made a remark that reminded me of something that might get us off one way or another here. There was a little church in one of the rural sections of Virginia that had a pastor, and the chairman of the deacon board had arranged for visiting ministers to come and speak. And as as is the custom in rural Baptist churches anyway, they felt the duty of the chairman's wife to prepare a meal for the visiting minister. And of course everybody's looking forward to hearing it. And he appeared that Sunday morning, and she ushered him tried to usher him to the dining room. He said, "Oh no, he never ate before he spoke." So that disappointed her quite a bit, because she had planned on being through with the meal and being able to go to the church and hear the sermon. So the best thing she could do then, because she had to stay there to keep the food hot and keep it from spoiling and whatnot, she sent her eldest son to go along and hear the minister and come back and report to her as to what had happened. So he did, and she was at the front door looking to wait. And he saw him coming, he came up, and said, "What's the gentleman? How was the minister?" And the boy very laconically stated he should have ate. Well, I just want you to know I have ate. So if you get disappointed, I'm all to do it. I want to thank Professor Ball and whoever else contributed to it for extending the opportunity for me to participate in this program and to meet the very charming people that I met this evening that I had not met before. I also want to congratulate the committee and Professor Hershke for this marvelous opinion on cases and the interesting questions presented. I was only disappointed in one little thing. Where is the professor? I don't see him. But anyway, I would hope that he would have had I would have liked for him to have had Justice Marshall's dissenting opinion in the Parkey case, because that sort of sets out how blacks feel. Now, he gave you some very excellent suggested readings, Simple Justice, and one or two others. I'd also like to suggest that those of you who want to do more reading on this subject and who really are interested, to read Justice Harlan's dissent in the civil rights cases. It appears in 109 U.S. at page 3, and of course the dissent starts at page 33. And also, very, very informative article is one written by Arthur Kenoy. It was published about 20 years ago in the Rutgers Law Review in volume 21 at page 387, entitled "The Constitutional Right of Negro Freedom." The cases for discussion this evening and the several questions posed for consideration have relevancy only because of past deficiencies of some of the judgments made 200 years ago by our founding fathers, whose achievements we are currently commemorating. And the faulty reasoning 100 years ago by a majority of the members of the Supreme Court of the United States in such landmark cases as the civil rights cases of 1982 and Plessy versus Ferguson. The article that I mentioned just a moment ago by Professor Kenoy, I'd like to quote extensively from it because he speaks much more succinctly than I do, and I think he puts forth the question that I would like for you to ask in considering these cases in light of this historical perspective. At the center of the complicated conceptual problems with which the Supreme Court has wrestled over the years in the area of Negro rights has been the failure to define with any preciseness the nature of the new substantive rights affirmatively created by the post-Civil War amendments, 13th, 14th, and 15th Amendments. All of the unresolved issues which presently face the court in this critical era involve this question, is at the heart of the still elusive state action, metaphysics, and it is the crux of the federal-state relationship dilemma. It determines the dimensions of the responsibilities of the national executive, the national legislature, and the national courts, and it underlines the confusion which is generated by the decision of the last several year terms, redefining the available federal enforcement remedies for the protection of the constitutional rights of the Negro. Further, it may well be at the eye of a hurricane which is gathering as the court again appears to be considering the alternatives which once before, in 1877, led the country to the fateful conclusions affecting both the Negro and the future course of our national life. Bearing Biden in mind, I make sure that Kenoy gets all the credit is entitled to because I quote from a little before. As Kenoy explains it, at the heart of Justice Harlan's analysis, and Justice Harlan was the dissenting judge in both the civil rights cases and later in the Plessy versus Ferguson case. In Justice Harlan's analysis is the proposition that in eliminating the institution of chattel slavery, the nation had enacted a new national constitutional right, the right of the black man in America to be free. That this right of Negro freedom carried with it the right of the race of freedmen to be free from the stamp of inferiority imposed by the badges and indicia of the institution of human slavery. The right of black men to enjoy equally all the rights, privileges, and immunities previously enjoyed by white men, and the right of black men to assume their position as equal, quote, persons, end quote, among the political community established by the founders of the people of the United States. This new national substantive right of Negro freedom was a separate and distinct right, while the right of Negro freedom was the catalyst in the emergence of the broadly encompassing 14th Amendment, concepts of due process and equal protection. It was more importantly the heart of the wartime amendments. It was not merged into or diluted by these more general guarantees of fairness and equality which were designed originally as a protective shield for the basic constitutional right of Negro freedom. The simple fact status of inferior beings. A status imposed by the system of chattel slavery to what of free men and women, equal participants in the heretofore white political community consisting of, quote, people of the United States. The constitutional right of the black race to this status of freedom was the simple and central objective of the Reconstruction Amendments. And this is an important concept because, for the most part, people seem to feel that once something has been declared, that's about it. But we don't recognize the depth of the function that was given to the status, rather, that was given to the blacks as a result of these amendments. What you got to bear in mind is that, regardless of what you've heard from time to time, the Constitution has never been colorblind. The original Constitution provided for slavery. It provided that the importation of blacks could be, it was extended from nearly 20 years after the adoption of the Constitution of 1897. It also, and here is one of the things that's really the crux of the situation, it provided for the right, and this is in the Constitution, now it provided a right for the slaveholder to go into the free territories and recapture his slaves if any of them should be lucky enough to escape. And it also provided for the enactment of legislation by a congressman. I'm sure in your historical books you've read about the fugitive slave laws, how much that created problems in not only particularly in the Ohio and Pennsylvania, the border states, because Negroes did escape, and there have always been decent-minded people who were willing to try to help them. And these created those kind of problems. But the thing that I want to impress upon you is that this right to regard the blacks as property, which they did in slave holding states, did us all that regarded blacks as, was a constitutionally guaranteed right to them. Another feature that shows that the Constitution was not colorblind so far as blacks were concerned was because, if you also recall, that for the convenience of the South, they made this property 3/5 of a person, so as to enable the South to increase its congressional representation. But now this situation continued to exist with a worsening situation until the Civil War. When the North won, and the Confederate States were defeated, the slaves were freed by proclamation. But what did the South do? They immediately reenacted what are known as the Black Codes. And these Black Codes did all that it possibly could to re-enslave the blacks. I mean, it not only tied them to the soil, but it made it possible for landowners to go through with a process of semi-slavery. They did this by declaring anybody who was unemployed, if he couldn't satisfy the authorities that he had employment, a vagrant. And if he was a vagrant, he could be arrested, taken in, and confined. And also the laws generally provide for whoever paid his fine had his services. And of course, if he, for some certain period, but the situation was such that once you got invested in that process, you were just there. Now, not only were these kind of laws passed, but also physical force and violence used to keep the blacks on the farm. So, to meet that situation, it's been referred to as the radical Congress, but I say they were compassionate men and women, or men rather, because no women doing anything those days, in the political era. They were compassionate members of Congress under the leadership in the House of Thaddeus Stevens and in the Senate of Charles Sumner, who pressed and obtained the adoption of the 13th and the 14th Amendments and certain civil rights acts, like the Civil Rights Act of 1866, 1865. And more importantly, though, having gotten the 13th, 14th, and 15th Amendment, they then enacted statutes to carry out the force and effect of the constitutional right. Now, these were the cases that when people violated these laws, they denied Negroes the right to go to the inn, denied them this right, denied them, segregated them on transportation, they were arrested under the authority of the statute. And these were the cases that came up and known as the civil rights cases. The majority of the court said these rights only apply to wrongs committed by the state, and they did not apply to wrongs of individuals. That they were just left there in a situation where an individual wronged you, you were just like you would have any other right of action in a civil court, but you had no right for the government to come in and do something about it. That was the thesis upon which Bradley operated, and which, on the basis of that, he held that the Civil Rights Acts of 1875 were unconstitutional. And that threw Negroes right back to where they were, subject to all the possibilities of segregation that we endured for the past 100 years. Justice Harlan said no. The 13th and 14th Amendments were adopted to remove these vestiges of slavery and to confer upon blacks all the rights and privileges of a citizen of the United States. And that, therefore, the acts were merely performing a function of the statute and carrying out the constitutional mandate. Now, I call your attention to the fact that there's a difference in this reason. You recall that no one complained, or certainly no one in the South complained, when they enacted the fugitive slave law under the provision in the Constitution and forced people to help them bring their slaves back. That was where the federal government was using its power and influence and effectiveness to protect the property of slaveholders. But when we came around to protecting the civil rights of blacks, they said, oh no, you can't do that. That's intrusion upon the rights of individuals. That denies the in people the right to choose who he should have. And we all know that from early common law, the in people was required to provide facilities to anyone who came and met the ordinary requirements. But it would not apply to it. It also violated the section of the Constitution that provides for all citizens. In the first place, the 14th Amendment made blacks citizens of the United States. And even the earlier Constitution, in the basic Constitution, rights of citizens of the United States to the equal protection of the laws were guaranteed. If you left your state and went to another state, you were still entitled to the protection of the laws and to enjoy all the privileges and immunities of any other citizen of that state. So Bradley's concept, and this concept of segregation, violated that part of the Constitution of the United States. Now that situation existed, as you well know, up until Brown versus Board of Education, where the court came in and said segregation in public schools is inherently unequal and unconstitutional, and from that up to the present time, we've been getting cases holding and extending the rights of blacks. That brings me up to a point I would really like to make, and then we'll open up Professor Jones and maybe questions, which I'll probably do a little better. Take the concept of poverty. Justice Powell's decision said that blacks was discriminated against. Well, so far as I'm concerned, blacks was not discriminated against. And I say this, and he was the defeat thing, they say he's innocent victim. Well, that assumes that there is a culprit, because to be an innocent victim, it has to be somebody imposing something on you. But the blacks who were trying to go to school, who were provided for by the Davis, in what they call the quota, I always say it was a constructive goal, they were just as much victimized as white. And this idea that you can correct a situation without anybody suffering is contrary to all human existence. I wrote an article, well, I wrote a statement in an article a little earlier when I was talking about Brown, which I can express very nicely what I want to say here now. And that is, I cannot understand how some people who favor sending soldiers and civilians to foreign lands all around the world to make the American presence felt in support of democracy, and who find the loss of hundreds and even thousands of American lives an acceptable risk to accomplish this objective, can simultaneously claim that they cannot bear to countenance as an acceptable risk the use of its power by the United States government to effect democracy in the United States if it causes some inconvenience to some students or temporary loss of employment opportunities to a few whites. In other words, it is acceptable for a black or a white person to die on foreign soil to promote the prestige of the United States as a democratic nation. But it is unacceptable for the United States government to use its power to obtain democracy for blacks if such use inconveniences some white person. I consider the reverse discrimination argument a convenient ploy in support of segregation as usual. That wasn't where I originally planned to stop, but I think that's a good place to stop and let you ask the question.
Mr. Hill, thank you. We will have a discussion after our respondent. I think what we will do first is give Mr. Hill a chance to respond to the respondent if he so desires, and then we will open it up for questions. And this, of course, is one of the major portions of this whole series. We hope that we will get some good questions from the audience. As respondent, it's my pleasure to introduce Professor John Paul Jones, who is one of my colleagues. He teaches at T.C. Williams School of Law. He is in his 6th year at the University of Richmond. Professor Jones is the law faculty's Distinguished Educator of 1987. He teaches constitutional law, as well as a variety of upper-level public law courses, including administrative law, civil rights law, and military law. He came to Richmond from Yale Law School, where he took a master's degree in law in 1982. He was graduated magna cum laude from the University of San Diego Law School. He has a BA from Marquette University. He is a member of the Virginia, California, and federal bars. He has served as a judicial clerk at the United States Court of Claims, as a judicial extern at the United States Court of Appeals for the Ninth Circuit. May I present Professor Jones.
Thank you. I'm not really comfortable with the title of respondent when I stepped up to the lectern after Oliver Hill. One of the things that we can do as lawyers is we can go back and we can look at great battles in the law as they're recorded in the reports. The Supreme Court reports, like old movies, you can see they cast the characters. Each year I go back and review Brown versus Board of Education, one of the greatest landmark cases in the country. And as I go back to the characters, whose names keep coming up? Oliver Hill. You can He was on brief for the companion case, Brown. Brown was actually 6 cases combined in one. One of those cases coming from Prince George County. And it was Oliver Hill, along with his partner, Spotswood Robinson, who argued that case on brief and argued the case before the Supreme Court. So it's like stepping up here and trying to respond to one of the Minutemen themselves. When they say, I'm going to respond to Oliver Hill. It's actually an honor to call him like that. The other reason I'm uncomfortable with the word respondent is that most of what Mr. Hill says I agree with. And I find myself in something of a dilemma. So I'm going to try and satisfy both my role as respondent and my own academic integrity by first telling you what I expect a true respondent would say to Mr. Hill, and then talk to you a little bit about how I can find some common ground between those two positions. Mr. Hill's perfectly right when he says that the crux of this matter of equal protection is the definition of the word state action. The Equal Protection Clause in the 14th Amendment begins with the words, no state shall. It has often troubled people that the 14th Amendment's Equal Protection Clause does not begin with the words, no person shall deny others equal protection of the laws on the basis of their race. People disturbed by that language, people faithful to the proposition that the words of the Constitution, as many of them as possible, ought to be given meaning, focus on the beginning words, no state, and conclude that the 14th Amendment's guarantee of equal protection does not protect any of us, particularly minorities, from racist action by private parties, but only racist action from government or in exchanges between minorities and government, such as voting, or holding public office, or sitting on a jury. Those people, who I will call the new school of constitutional colorblindness, feel then that the equal protection guarantee created by the post-Civil War amendments is a guarantee of protection not from all racist threat, but only the racist threat that comes from government. 100 years ago, the dispute was, in civil rights cases, the degree to which the federal government could, by statute, enforce the rights established under the Equal Protection Clause that begins no state. Justice Bradley focused on the words no state and said, yes, the federal government can protect blacks, but only from states. Justice Harlan focused on the intent behind the 14th Amendment and said, the words no state do not limit the federal government. The federal government may protect, at least with respect to public transportation, public accommodation, minorities from the racist actions of private individuals when those private individuals are operating with the consent of the state. That was 100 years ago, and the decision was decided against Harlan in favor of the limited view of the 14th Amendment. Bakke is the harbinger of a new round in that same dispute. Does the 14th Amendment provide adequate protection from all racism or only protection from governmental racism? Bakke was the harbinger that got Bakke because of the split on the court could be viewed as not deciding the constitutional question. What is the constitutional question? Of this century, can government disadvantage or burden whites to respond to racism against blacks and other minorities at the hands of private parties? In this century, we make a great deal of the distinction between what is called de jure segregation, that kind of segregation, de jure discrimination that is practiced by government, and de facto discrimination, that kind of discrimination that is not practiced by governments, but is practiced by private parties in their social and economic decisions. The Bradley and Harlan positions are represented today on the Supreme Court with in the form of new justices. The dispute is, can we disadvantage a white? Can we burden a white to relieve a black from the harm done by private, non-governmental discrimination. In a recent case, Wyden versus Jackson Board of Education, decided in 1986, 4 justices of the Supreme Court joined in an opinion that expressed the view of the new school of constitutional colorblindness. The 14th Amendment is a guarantee of equal protection, whether that protection be afforded to blacks or whites. Race cannot be used as a discriminator for the best of intentions. For the best of intentions when that intention is to respond to the social evil of racism practiced by other parties. I don't think that school has had its last say. I think that school on the Supreme Court is a viable one and may yet become the majority of the Supreme Court. If that is the case, then Bradley's decision in the 19th century will be followed by a decision shortly in the Supreme Court that says affirmative action is only available when governments practice racism. Affirmative action is not available when private parties, through their social and economic decisions, practice racism. Now, I've given you the views of the new school of colorblindness, and I must say that that's as good a job as I can do for those folks. I find myself somewhere in the middle on this debate. I want to be faithful to all of the words of the Constitution, so I want to give meaning to those words that begin no state. I don't want to ignore those words as they announce or begin the statement of the guarantee of equal protection. By the same token, I'm troubled by a view of the Constitution that says that the Constitution itself forms a barrier against government reacting to one of the greatest social ills to face the country. No such barrier is raised should the government choose, in its infinite wisdom, to eradicate poverty, to eradicate illiteracy, but to eradicate racism. The new school of colorblindness suggests that the Constitution itself prevents the eradication of racism. I'm troubled by where I must fall, being faithful to the words of the 14th Amendment, and yet faithful to the proposition that the Constitution itself cannot be the barrier to the cure of fundamental ills in the nation that it serves. Where this takes me is once again back to the 14th Amendment and to the words no state. I look at those words and I say, by golly, that says no state. It doesn't say no government. The Equal Protection Clause, the guarantee of equality in treatment on the basis of race, exists in a clause that operates expressly only against state governments. It says, no state shall. I look in vain for the equivalent express limitation in any part of the Constitution addressing the federal government. Finding no such limitation, I conclude that where the Congress of the United States makes the decision that affirmative action, even when it burdens whites, to the benefit of blacks, as in hiring quotas, as in admissions quotas, as in contract set-asides. When the federal Congress decides that that is an appropriate response to a national malaise, and when the federal government has power to respond to that malaise, as I believe it does at least under the Promise Clause, the Necessary and Proper Clause allows the federal government to do what it wants in that area, including affirmative action, because the Necessary and Proper Clause of the Constitution permits the Congress to do all that which the Congress is not expressly forbidden. And I began by saying the Congress is not expressly forbidden from violating the Equal Protection Clause. Now I would go one step further and assure you that I have not just offered you an interpretation of the Constitution that would allow the Congress, unconstrained by the Equal Protection Clause, to act using race as a discriminator for racist motives. The Equal Protection Clause operates against states There remains in the Constitution another clause that does not guarantee equality on the basis of race, but does guarantee the government, the federal government, will never act arbitrarily or irrationally. That clause exists in the Fifth Amendment. It is the Due Process Clause addressed to the federal government. Where this takes me is that the Due Process Clause of the Fifth Amendment prevents racist discrimination by Congress, but does not prevent other uses of race for legitimate purposes, one of which is to cure the disease of social or private racism in the United States. Justice Stevens, in his dissent in the Wigand decision, has acknowledged, as one justice has said, there are uses of race that are not totally irrational. Has recognized at least two of those. One was the use of race that was discussed in the Wigand case. In Wigand, a school board attempted to protect junior black school teachers, junior in terms of seniority, from layoffs at the expense of more senior white teachers. The purpose the school board had in doing this was to guarantee that there would be an adequate number of role models for black students. Those role models being denied black students as the result of social, economic, but not governmental discrimination in the past. Justice Stevens recognized the use of race in that regard as a potentially rational use. I take his agreement with me that there are rational ways in which we can discriminate in affirmative action. And I tie it to the distinction between the Due Process Clause and the Equal Protection Clause. I can offer the solution of affirmative action for social and private racism when it is enacted by the federal government. I must acknowledge, however, that affirmative action to repair the damage done by private discrimination is not available to state government. It's a national problem. A national response lies innate in the Constitution. Thank you.
I think we'll give Mr. Hill first opportunity, and then we'll open it up to the audience.
Well, I don't necessarily disagree with the main thrust of them statements. Obviously, they coincide with my views. I'd like to just call your attention to one other thing that is overlooked in all these actions when they say no states will do other things, but they completely ignore the part of the law which says that no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States. And the point I want to impress upon you is that from its inception, white people were citizens of the United States. And the 14th Amendment made all persons born or naturalized in the United States, because up until the 14th Amendment, blacks were not citizens of the U.S. Most times they were citizens of the state, and in the Dred Scott case, it was declared they were not citizens of the United States. So the 14th Amendment made blacks citizens. So that meant that they had all the rights, privileges, and immunities of white citizens. And from time immemorial, from going back from the old common law in England up to the present time, whites had free access to all of the places of public accommodation and that sort of thing. Nobody's arguing about if you don't want to invite me to your home, then I got some right to come there. I probably wouldn't be just as anxious to stay away as you are to keep me away. But when we go dealing with things of a public nature, and when we're dealing with things that deal with the public, after all, in our society, we say we operate in a free enterprise society, and everybody is expected to do what he can to provide for himself and his family. So that is a universal function, and not anything of that nature, whether it be for your enjoyment slavery and did all they could to protect the property of the slaveholders. When we became citizens, the federal government, as I insist, has got a right now to open its eyes and do whatever is necessary to bring along this flow of people until we reach the point where we can be integrated, and the Constitution can become colorblind. That's an aspiration, but it's not an existing fact.
We'll open it up for questions at this time. Okay, Gary?
I just like to try out a theory to see if we can figure out how the states can prefer black people at the expense of white people. I think the court, either in Wyden or other cases, said that the state can fashion remedies for illegal discrimination to eliminate the ongoing pernicious effects of previous discrimination, previous illegal discrimination. Now, that previous illegal discrimination doesn't necessarily have to be constitutional discrimination. We've had a Civil Rights Act on the books since 1964, which prevents private discrimination. Private discrimination since 1964 is illegal. So a state, in order to redress the continuing effects of that illegal private discrimination, should be able to fashion a remedy, which would be a reasonable preferential action remedy. What do you think?
Who would you like to respond to that?
Well,
other than me?
Well, I'd like both gentlemen to respond, so I'm going to benefit of both of their reviews.
Yes.
Well, I gather from what you say is that operating under the Civil Rights Act of 18, well, Title 7.
Yes.
The government should not, certainly this way, I can point this out, as in Berkeley. All right. University of Davis Medical School, of its own volition, instituted a program to try to meet an existing situation that everybody recognized. The need to provide opportunities for more blacks to get a medical education. All right. I say that for the government to come in and say that they can't do that is a violation of the law. The only person who really operated correctly in the Barker case was I think it was Justice White, who said that Barker had no standing. Everybody else assumed he had standing, but Justice White, if you recall, said he had no standing. The case had been thrown out for that reason, and I think he was right. Now, of course, those the four who held that it violated the Constitution, Justice Berger and the rest of them, found standing. Justice Brennan and Marshall and those who sided with him assumed that they were standing. They just said, well, we're going to tackle the issue. But really, I don't think that he had any standing, because this was a voluntary act on the part of the school, and they had a perfect right to meet a social problem without interference on the part of the government. As a matter of fact, I say that the government should have actively come in and caused one to do so, come in and protect that right for them to do so.
And that man is a ringer, by the way. That's Professor Letus, my colleague in constitutional law. Gary, my answer starts out by saying, sure. And then the next step it takes is, from my point of view, when Congress passes the statute that forbids private discrimination. It's exercising its Section 5 power. The neat question is, can it, exercising its Section 5 power, delegate to the states, either directly or through court authorization? Can the feds, so to speak, can they delegate to the states the power to disregard Section 2 by helping to carry out Section 5?
Well, Your Honor, I mean, the states have all the reserved powers. They can legislate for the common good, so long as they don't violate equal protection laws.
Right.
Now, if they're legislating a remedy for previous illegal discrimination in that state violating federal law, I don't see how that violates equal protection power. So instead of relying on the commerce power of Section 5 of the 14th Amendment, they have the reserve powers to legislate for the Commonwealth. And as long as it doesn't violate the equal protection clause, which would be a check on the reserve powers,
Right.
then I think they can fashion remedies. I don't think they're preempted by any federal laws to fashion remedies for black people who are the victims of illegal discrimination in their state. It may be that, let's say, God willing, someday we reach the point where only 2 states have illegal discrimination. Then those 2 states should be able to cure it because Congress may say, well, it's not a national problem anymore.
I'll buy into that, but I don't know if the colorblind school could buy into the proposition that left after the passage of the 14th Amendment in the states was the innate power to defy the clear-cut language of Section 2, which says no state shall deny the equal protection of the law.
But you have to say that a remedy isn't a denial of equal.
I can do that, and I can come out of it. I can get there with you from a different path, which is coming through Section 5 in congressional action. So we'll end up in the same place.
That's all that counts.
Further questions? I have a question over here.
To allow affirmative action, which some people refer to as reverse discrimination, to rectify the rights of disadvantaged minorities, to bring them to a level of equality. When will we know that we've reached the point where this is no longer necessary? What magic numbers do we have to reach to stop doing this?
Is that addressed, Mr. Hill?
I'll take it. I can't say that anyone can figure a magic number, but there will come a time, I hope, when you can recognize the fact that the person's color doesn't make any particular difference. But for anyone to say that we do not live in a plural society today is absurd. How many people do you think, white people I'm talking about now, who, how many have you ever heard admit that they have any ancestry, African ancestry? So there isn't any question about it. If someone came up to the average person here and say, I have been doing some studies, been in genealogy, and I found that old Jim Jones, a white planter, was Negro. And remember now, according to Virginia law, he could have been way back there. And if he had an African ancestor 100 years ago, and we could trace him on down to you now, under Virginia law, you were black. And you know how many of you would feel comfortable in that situation. So I say until we get to the point where we really, I'm talking about society at large now, I'm not even individual, society at large really makes no difference to them blacks or whites, and if you've got some black ancestry, there's no big deal, then that would be the point where the Constitution would become colorblind. But up until that time, in order to bring that situation to pass, then I say we need to look with both eyes in dealing with this problem and do whatever is necessary to facilitate it rather than to hinder it and prolong it.
first, I'd like to say that with a name like Jones and a family as large as mine is, I hesitate to make any claims of any kind. But in response to your question, I think it depends on what the purpose of the affirmative action response is. If the purpose of the affirmative action response is to remedy past illegal discrimination, the Gary statutory illegal or the constitutional illegal, then who you have to convince are the judges. They've been convinced. The Richmond School District case recently shows that judges can be convinced that affirmative action is no longer required because the effects of past illegal discrimination are gone. The Norfolk or Tidewater case is another example right here in Virginia. If we're talking about affirmative action responding to simple societal discrimination, private discrimination not otherwise made illegal, convince the Congress. The Congress for the foreseeable future, in my mind, will be controlled by white people. White people who create affirmative action programs that burden white people. I can't imagine them continuing to go along and do that once they no longer feel the call of justice to do so.
Further questions?
With respect to the current scene, the debate for the Senate Judiciary Committee, do you see a regression occurring no matter which way the war? Do you think that things are in a state in which we may anticipate a retrenchment and a backing away from the advances that we would suggest began at the ground?
Well, isn't any question about it. Once upon a time, we viewed the federal court as a haven. They're no longer regarded particularly as a haven right now. I mean, the regression has been going on for several years. Affirmative action, gosh, you've almost got to prove all kinds of overt activities before you can win a case in affirmative action anymore. Then on top of that, they enacted rules. If the judge thinks that your case, in light of precedents, should not have been brought, he can fine you. I mean, well, you impose costs on you, attorney's fees and cost of court and all those sort of things. So we had a case here, which I thought was ridiculous, coming out of either Henrico or Chesterfield County, I don't remember now which, but it was a young man on a band, and they attempted to ostracize him, and they brought the case in court, and the federal judge said all the rest was frivolous, and imposed penalties on the parents of that child. Now those are white people, and the same situation can happen with respect, and do happen with respect to blacks. Practically all the cases go up now. The set-aside, 10, 12 years ago, the majority of the court would have upheld that. Today, the Richmond set-aside, they said, turn it back. You're not entitled to it. And that kind of situation has been going on and continues. So there isn't any question about the fact. And then also, here's another problem that we always confronted with. We're living in this plural society. Very few white people have an opportunity to meet the ordinary, low-wage Negroes. So the consequence, they don't have a contact with the problems these people have. And everywhere today, these mergers and whatnot, business mergers and whatnot, they're taking over companies, reorganizing, and paying people from 2/3 or 1/2 for the salaries of people getting. Of course, that's affecting white people also. And there are a lot of things like that happen. And those kinds of things are going to make competition for jobs, better employment. There's something else you've got to remember. Regardless of what the white employment is, unemployment is you can always bet your bottom dollar that the black employment is twice or a little couple other percentage points higher than that. So, and they start out with the least amount of resources to start out with. And then, of course, when they come unemployed, it creates a big social problem. And people have to go on welfare and that sort of thing. That irritates the taxpayers because they feel they're supporting lazy people. And as a consequence, you create, instead of improving the situation, you create further and further irritants and causing a bad situation to become worse.
Would you suggest that since 1980 things have gotten worse because of the kind of federal judges have been appointed?
No question, but if there are people who are unsympathetic with affirmative action and such social programs, and President Reagan's ideas and things are just not conducive to benefiting the ordinary poor person, white or black.
Further questions? Yes.
Yeah, I have two. The one I would like, since we've been talking a lot about affirmative action, take a look at the Bakke case. Is there some other way than affirmative action to reverse the discrimination that blacks have been feeling? What should we do since we have affirmative action? Is there something else to replace it? And also in regards to the Bork hearings, with a good chance that Mr. Bork will not be on the Supreme Court, who do you feel would be an adequate person to fill that vacancy?
Nobody that has any possibility to be one nominated by. What was your first question?
What could you find to replace, say, affirmative action?
That's the big problem. These people talk about reverse discrimination, they talk about all, and they talk about anti-busing and all those sort of things. But no one yet has come up with any program that will alleviate the situation. We fought against busing. Well, busing had a very, let me tell you this, busing had a very peculiar history in Virginia. The first case I carried to court was on behalf of a man who had a son and a daughter who lived 40 miles from the school with no transportation. But now they provided transportation for white children. And have always provided transportation for white children from the turn of the century. Negroes have been walking up until in the 30s when we started doing something about it. But now, busing was always an ideal situation. As a matter of fact, it was busing that made it possible for the counties to consolidate their funds and produce a decent high secondary education for children, for white children that is, because in those days, they sent black children to what they call training schools. They didn't pretend that they would give them a decent education. But all my point is that nobody comes up with, when the poor or so-called liberals come up with ideas like busing or doing something else towards the situation, they object to it. But nobody ever comes up with any constructive program to meet the situation and correct it of their own position. Now, Judge Merritt had a wonderful idea. Open up the schools, erase the political lines, so that's already artificial. But the Supreme Court, our Court of Appeals voted against it, and the Supreme Court let it stand on a divided court decision. But that would have done a lot of good. Now, what did happen after that? The political people went to the legislation, and as a matter of fact, what they've done was contain Richmond. We can't expand or can't do anything. We contain that there now to prevent any such thing as that, even prevent the city from annexing some more land and spreading the situation out. So you can find innumerable examples where efforts were made to block the Someone else over here has a question.
Yeah, I'll do another one now. As a possible alternative to affirmative action, I'm thinking on the model of the Head Start program. Whether it would be workable at a later age, I don't know. But it seems to me that the Head Start program is a matter of neutralizing a disadvantage rather than preferential treatment. It seems to me that, for example, you can have neutralizing a disadvantage for 3-year-olds in disadvantaged homes, whether they're black or white, whether they're in Appalachia or New York City or Los Angeles, and have that program without any consideration as to past discrimination, past social injustice. And that's a case in which I suppose there is even there a burden or a disadvantage on some whites, mainly the taxpayers. And I suppose one could even look upon it as I really can't, one could try to look upon it as a burden to the children who come from well-off families, so they don't get to first grade, ahead. In other words, the notion of bringing people up to the starting line equal as distinctly providing as a preference in the treatment. It seems to me that is theoretically, not illustrated in the Head Start case, an alternative to affirmative action.
He's open to something, but I don't particularly agree with it. Now, I would concede that one possibility would be the thing that has been done in some communities, that is, put up a model school and invite all people to come there voluntarily. That has some virtue. But nothing is going, nobody's trying to say that everybody's got to be equal. We all recognize the fact that there's no possibility in the foreseeable future of all human beings being equal. They haven't been equal all these thousands of years. There's no reason to believe they're going to become equal anytime soon. And that's not the idea. The idea is for people to have an equal opportunity. And also that you have sufficient mix in the society so that people won't be uncomfortable with other people. I don't think everybody around the world, I'm a world, one world, but I don't think that everybody in the world should have identical cultures. I don't want to wipe out all the varying cultures. All I want to do is people to be able to, regardless of where you go, you meet another individual, you accept them on their basis and on their worth. And also recognize the fact that what you're trying to do is to maintain, develop and maintain a world in which we can live in peace and harmony and not waste our resources in wars and armaments and preparing for wars. If we could wipe out the need for wars or the supposed need and apply that money to constructive purposes, we wouldn't have no problem. It doesn't make any difference whether you're an Eskimo or in China. You have the same needs as a person on Park Avenue in New York. You need to eat, you need housing, you need health care, you need opportunity for recreation, you need cultural advantages. All human beings ought to have the opportunity for those things, and that's the kind of thing we need to aspire to. And stop this idea about we got to compete. Fortunately, we are beginning to get new ideas and new evidence is being explored. We recognize the fact that there was at one time, before this authoritarian, male-dominated, competitive society came into existence, there was a time when, apparently, judging from what we can get from fossil evidence and so forth, that people did live a much more peaceful life than what we need. And what I want to do is work on a cooperative and participatory type of situation where we go in and try to establish democracies by example and teaching around the world. Suppose, let me sit down, my wife's already said, damn. Suppose this, when the founding fathers established our Constitution, let us suppose that they had sufficient faith in the democratic process to extend the right of suffrage to poor white men, white women, to blacks, and to the Indians. Suppose that they had sufficient faith in the free enterprise system to have freed the slaves and paid them wages. And suppose also that instead of going around the world preaching the doctrine of manifest destiny and white man's burden, they had gone around the world preaching democracy. Think of how far we'd be ahead today rather than where we are. So there's a whole lot to think about. There's a whole lot for us to do. And one of the things we've got to learn to do is have more cooperation and less competition, except in the essentials of life.
We'd like to thank the Virginia Endowment for the Humanities for their support of this evening's program, and I would like to remind you that we have the last program in this series a week from today, Thursday, in this very room. We hope that we'll be able to see many of you at that time. Thank you.